one as being a criminal and putting a young person in a facility, theoretically, where they could be in real danger. And we're talking about people who are here lawfully, and now we're talking about children. I mean, you know, if our colleagues are not moved by the fact that there have been overzealous and ludicrous prosecutions under this Department of Justice, maybe they're just moved by the politics of it. This just looks ridiculous. It's going to make America look ridiculous in the eyes of the world that we're calling kids criminals.
It's going to be another kid in a bunny hat situation for you guys.
Well, I just think we shouldn't go down this road, and I wanted to yield to the gentlelady from California. I think she also had something to say here.
So agree in supporting this. And as I'm thinking, there were some hearings ago when we actually were talking about legislation to cut federal funding. So you want to cut the courts, you want to cut funding going to the courts, you're going to have these federal charges. These are courthouses that are already under-resourced and overwhelmed. We are throwing more things on their calendar because we are trying to, you all are trying to pass these preposterous pieces of legislation that only do more harm to the court system. And then you're going to add to that by detaining kids. Now maybe, and I love it, the colleague from Texas said, I don't think you need to be so prescriptive, but actually we do have to be prescriptive because prosecutorial discretion is all about the discretion that someone has. And so we cannot leave it up to rogue prosecutors. You do need to be precise, which is why we should be supporting this kind of legislation to lay out very specifically that we are not trying to, that we don't want to detain children, we don't want to charge children, and there are 2-month-old babies actually in these detention facilities right now.
Yield back, Mr. Chair.
Who seeks recognition?
Mr. Chairman.
The gentleman from Missouri.
Thank you, Mr. Chairman, to speak against the amendment. Mr. Chairman, this is no time to be watering down the visa overstay part of this very important bill. In fact, I believe this is one of the most important parts of this bill. You know, prior to the Biden open border policies, the majority of the illegal aliens in our country were visa overstayers, including at least several of the September 11, 2001 hijackers, including Mohammed Sabre Soliman, who was the Boulder, Colorado terrorist who yelled "Free Palestine" and threw ignited Molotov cocktails on...
Would the gentleman yield?
Let me finish and then I'll yield. At peaceful demonstrators advocating for the release of October 7th hostages, and also including an illegal alien visa overstayer from the Middle East who sexually assaulted 2 female victims in my own county of St. Charles, Missouri. So I think this is a very important part of the legislation before us today, and I do not believe we should be watering it down. Thank you, and I yield back.
Oh, well,
I will yield back to the representative from Texas.
oh, not to me. Thank you.
Well, you would yield to. The point that I'd like to make is we do prosecute, under current law, juveniles for reentry. We do it under 1825 regularly. Under the Obama years in 2010, 191 cases, 2011, 153, 2012, 138. These are all the Obama years. And then, you know, fast forward, and, you know, we even did some during the Trump years. There was sort of a decline. I'm going to go look at the numbers or throw the chart up. And then it dropped off precipitously, but there was a handful during the Biden administration. Notably, that means, by definition, they were carrying out, because of the numbers, they were carrying out prosecutorial discretion and choosing not to, for better or worse. I'm willing to bet that if I pry these numbers back, that there's a whole hell of a lot of 17-year-olds and 16-year-olds that were up to no good, that were a part of those significant numbers under Obama. I'd be willing to take that bet, and I'm pretty sure I'd win that bet. And so the reality is we do it, we've done it, and the evidence bears out that under our existing laws that prosecutorial discretion is at play, again, for better and worse. With that, I yield back to the gentleman from Missouri.
Yeah, I reclaim my time. I will yield to my Democrat colleague.
I just wanted to know whether the examples that you gave involved minors.
You know, I don't know exactly at what age each of the 9/11 hijackers entered the country. But, you know, again, when we say minors, that can mean 16 and 17-year-old gang members. It doesn't
Who came legally on a visa to begin with.
Yeah, and overstayed and then committed, some of whom committed illegal acts in our country, which is what brings them to the attention of law enforcement and gets them in ICE detention unless they're in a sanctuary city.
Well, this isn't about that. This is about automatically making them a criminal before they've done anything, before they've committed, all they did was stay here for more than 10 days. That's all we're talking about. We're not talking about people who are terrorists. We're not talking about people who committed crimes. We're talking about people who overstay a visa, by definition becoming a criminal.
And again, as my colleague from Texas has pointed out, these things can be handled with prosecutorial discretion. And with that, I yield back.
Well, the last time I looked,
The gentleman yields back. I recognize myself for just a few moments. You know, again, I'm sorry, it does have to go to a Democrat. I'm sorry. Who seeks recognition? The gentlelady from California.
Thank you, Mr. Chair. I'm going to yield some more of my time back to my colleague from North Carolina, but I do want to say I remain fascinated by these posters on the other side of the aisle, these 3-hour posters. And I was thinking, well, it's like 3 hours of Republicans running from the truth. It's 3 hours of Republicans holding a committee hostage, debating a bad bill. It's 3 hours of, I guess, some pinky agreement that was made about vote for this, to have this kind of hearing. And so I'm amazed. Yes, 3 hours, and we have not heard from the other side of the aisle any real substantive discussion about oversight and about what is happening with Department of Homeland Security and ICE. And now we're talking about overstaying visas for just a short period of time and doing harm to these young people. And so we're talking about, yes, another bunny ear situation, 5-year-old Liam Ramos. There was a child, a minor, who attempted suicide at the Dilley detention facility. There was a 1-year-old in a detention facility that got COVID. There was a nursing mother who was detained with her 6-month-old. There was another 6-month-old child being put in harm's way because of these grotesque practices. And the average time that these young people are in these facilities is almost 2 months. Almost 2 months. I mean, we're supposed to be a free world here, one of the richest, most resourced. And this is what we're doing to children. And not minors like at the 16, 17, 18-year-old mark. Children less than 10, less than 5. I could get into a whole thing about like people we know who could have been deported but weren't, who've overstayed their visas, you know, but I'm not going to get into it. But there's a ton of them. So it really isn't about anyone that overstays their visa. It's about profiling certain folks in our community who may have overstayed their visa and not even really knowing if they have, but picking them up. You know, that's what they do out in these streets, you know. They say, well, there's a 50% chance that this person might have overstayed their visa, might have strange immigration status, might have a weapon. I'm just going to roll the dice, pick them up and see. And that is not how we should be implementing law enforcement. So I'd like to yield the rest of my time to my colleague from North Carolina.
so I just want the gentleman from Texas to know that I'm not applying this to everybody. I'm a lawyer. I actually believe in narrowly tailoring laws to the actual problem. That is what this amendment does. You are talking about giving prosecutorial discretion to an administration that has been admonished by judges of all political stripes for how they use their prosecutorial powers. And we're seeing things that we rarely see. Grand juries refusing to indict. What happened to the expression, you can indict a ham sandwich? Grand juries are seeing prosecutorial malpractice. And you're asking us to take an overbroad law and trust the people who have abused the law? There is something very seriously wrong with that picture. This is the Judiciary Committee. Rarely does it act like the Judiciary Committee. It mostly acts like a three-ring circus of a bunch of posers. But I'm acting like a lawyer today because that is our job. And there is no reason to write an overbroad criminal law that sweeps in minors, particularly minors who have absolutely no ability to have a mens rea for this, to get themselves out of the country if they're here with their parents, and may be under difficult circumstances. And I cannot categorically trust this administration to do the right thing when it can't do the right thing under our current law. And I yield back.
Say, LaMonica McIver is my example of misuse of prosecutorial discretion. That woman was doing her job as a member of Congress.
Lady's time has expired. I recognize myself for a moment. This didn't happen in a vacuum. Again, we look at history. We see what's happened. We see what happened when the borders were open. We see what happened when we had so many individuals overstaying. And some of them, we don't like to talk about it, but some of them committed other crimes much more serious than the overstay. In fact, many of them who were in that 16, 17-year range of age certainly did. So this didn't happen in a vacuum. It's not something that somebody made up just for the heck of it. And I would hope and I would believe that at least the majority of prosecutors in the United States of America have the ability and the understanding to realize what their responsibility is. And if somebody is just overstayed and they're a minor, nobody's putting them in jail, nobody's hurting them. But if it's an individual who's a gang member, who's committed felonies, it's a different story. That's the point. This is just one more mechanism to get those folks that would do harm to Americans. And with that, unless somebody on my side has anything to say, I yield to the gentleman from Kansas.
Thank you, Mr. Chairman. I was listening to our colleague from North Carolina and her, I thought, well-placed principle that we ought to act like the Judiciary Committee. And I would ask you, Mr. Chairman, because I don't know this answer. I've never been a federal prosecutor, but listening to this, certainly the vast majority of juvenile proceedings in this country are handled in state court. And on very quick research, I've been doing a little reading about the Federal Juvenile Delinquency Act, which is characterized as suggesting that when you have a federal prosecution of a person under the age of 21, not just 18, federal authorities have three choices. First, under federal law, they can refer the juvenile to state authorities. I presume that wouldn't apply here since there's no state crime. Second, they can initiate federal delinquency proceedings, not the underlying criminal proceeding. Or third, if the case is retained in the federal system and involves a serious offense, they can then petition the federal court to transfer the juvenile for trial as an adult. And I'm just wondering, Mr. Chairman, if you know, would the Federal Juvenile Delinquency Act apply here? And if so, would it render the amendment unnecessary because it already resolves the concern of the gentlelady from North Carolina?
Gentleman yields back. I'm going to defer to Mr. Roy because he is a prosecutor, or was a prosecutor.
Yeah, I was. So your time, you've gone to him, it's yielded to me. I'm unadvised. What's that? Yeah, I mean, lawyers here, counsel said they believe it would. I'm unadvised. It's a reasonable question. I was going to bring up the Juvenile Delinquency Act earlier. I decided not to because I'm not expert on it, and so I wasn't going to dive into it. I would point out, just as a reminder here, 40% of the illegal aliens here are visa overstays. I'm just going to use my time to put that out there, but which is part of what we're trying to address. And the reality is, back to my point about this prosecutorial discretion, when you've got whether the gentleman's question is on point, or whether you're just simply talking about 17-year-olds, 16-year-olds, and others that then abuse the system, and then for whatever circumstances find themselves in having overstayed the visa, with or without the parents, or whatever the situation may be, I'm certainly comfortable leaving it up to prosecutorial discretion for them to make decisions about what to do about it. The point here is when you've given a time, then you're given the time to be here and a 10-day extension or a 10-day grace period. If you're not going to follow our laws, then there should be consequences, and they should be significant enough to deter it. I yield back.
Gentleman yields back to the gentleman from Kansas. We will get you a more robust answer, and maybe in time before this hearing is over as well. Who seeks recognition? The question occurs on the amendment offered by the gentlelady from North Carolina. Those in favor say yes.
Aye.
Those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Didn't sound like that to me, Mr. Chairman, but I'm asking for a recorded vote.
A recorded vote is requested. The clerk will call the roll.
Mr. Jordan, Mr. Issa, Mr. Biggs, Mr. McClintock, Mr. Tiffany, Mr. Massey, Mr. Roy. No. Mr. Roy votes no. Mr. Fitzgerald, Mr. Klein, Mr. Gooden, Mr. Van Drew.
No.
Mr. Van Drew votes no. Mr. Nels, Mr. Moore. Mr. Moore votes no. Ms. Hageman, Ms. Lee of Florida, Mr. Hunt, Mr. Fry, Mr. Kiley, Mr. Grothman, Mr. Knott, Mr. Harris, Mr. Onder, Mr. Schmidt. Mr. Schmidt votes no. Mr. Gill. Mr. Gill votes no. Mr. Baumgartner. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa. Ms. Scanlon. Mr. Neguse. Ms. McBath. Ms. Ross. Ms. Ross votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Garcia. Ms. Kamlager-Dove. Ms. Kamlager-Dove votes aye. Mr. Moskowitz. Mr. Goldman. Ms. Crockett. Ms. Lee of Pennsylvania. Mr. Issa, you are not recorded. Mr. Issa votes no. Mr. Klein, you are not recorded. Mr. Klein votes no. Mr. Correa, you're not recorded. Mr. Correa votes yes. Mr. Jordan. Mr. Jordan votes no. Mr. Grothman. Mr. McClintock votes no. Mr. Grothman. Mr. Grothman votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 10 noes.
The amendment is not agreed to. Who seeks recognition? Gentlelady from California is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Texas.
Amendment to the amendment in the
Without
nature.
objection, the amendment will be considered as read, and the gentlelady from California is recognized to explain the amendment.
Thank you, Mr. Chairman. This amendment strikes the provision prohibiting government funds from being used to provide counsel to to unaccompanied children and replaces it with a requirement that the government appoint or provide counsel to unaccompanied children. I think this is just a common sense. Children should not be appearing in immigration court without legal representation. And just envision what it's like. You've got, and this has been reported publicly, a 6 or 7-year-old child in immigration court. They're facing an ICE trial attorney and an immigration judge, and that kid is by themselves, and obviously they're not in a position to adequately represent themselves. Children fleeing persecution, violence, trafficking, as many of these unaccompanied children are, should be given additional protections such as appointed counsel. We should not expect children to act like adults. They have unique developmental needs, and it's really absurd to think that justice can be served with a small child appearing by themselves in immigration court. This prohibition in the bill would achieve statutorily what the Trump administration sought to achieve administratively, an effective end to the Office of Refugee Resettlement Legal Services Program for unaccompanied children. In March of 2025, ORR unlawfully terminated funding for legal representation of over 26,000 unaccompanied children. Now, a federal court enjoined the termination, finding that this action violated, among other things, the Trafficking Victims Protection Reauthorization Act of 2008. And I would ask the committee to recall that at that time, that trafficking bill was a bipartisan bill. We all realized that childhood trafficking victims needed protection. More recently, ORR has refused to pay legal service providers for essential services, and already one legal service provider has pulled out of the program after they refused payment, I think, unlawfully. Now, this bill does really abandon the long-standing bipartisan support for efforts to provide counsel to unaccompanied children. In the Homeland Security Act of 2002, Congress required the Office of Refugee Resettlement to develop a plan to ensure the timely appointment of counsel for each unaccompanied child. And in 2005, ORR contracted with the Vera Institute of Justice to advance this goal. In the PRA, as I mentioned earlier, ORR was required to ensure to the greatest extent practicable that all unaccompanied children are represented by counsel. This bill would put an end to those efforts and make it more likely that unaccompanied children would appear without a lawyer in immigration court while the federal government is represented by an effective and usually pretty aggressive trial attorney from Immigration and Customs Enforcement. I note also that children with attorneys are more likely to appear for their court dates. Children who are represented by counsel have a very high appearance rate, and the Executive Office for Immigration Review, fondly known by those of us in the immigration world as EOR, their data covered completed immigration court cases from fiscal year 2018 through the first half of fiscal year 2021, and it illustrates that this due process imperative, revealing that unaccompanied children without counsel were almost 100 times less likely to obtain legal relief in immigration court than unaccompanied children with counsel. Now, the National Association of Immigration Judges has weighed in on this, and obviously those judges are in the courtroom, and some of the observations that they share is that children may feign compliance to please the judge as an authority figure, and it's hard for a judge to need time to figure out if the child actually understands what's being communicated. Immigration judges really need to take more time with children who've been victims of emotional and psychological trauma, and that often is no longer the case in these proceedings. Children in proceedings need time to gather corroborating documentation if they're seeking relief, and immigration judges can conduct proceedings more expeditiously and resolve cases more quickly when children are represented by counsel. Counsel can direct their clients to available legal options instead of relying on an immigration judge to guess what the relief should be. This is a quicker process. It meets due process requirements that we strive to meet, guaranteed in our Constitution. I think it's common sense, and I hope that we can adopt the amendment. I yield back.
Generally yields back. Committee will just suspend for a moment while we look at the germane issue.
But the visa overstay one, are those kids recommended? No, because also this is a brand new scheme. Right. Because a visa overstay card is not right now subject to criminal consequences. It's just a civil. No, so that's what I'm saying. By rejecting the last amendment, she could literally get a minor as a criminal by being here, by overstaying and being here. So with respect to removal, it's the same thing. Don't know yet.
Yes, but they wouldn't be considered unaccompanied children. This is so right now, we have a provision that says that HHS should work on 2 children.
Committee will come to order. Does the gentleman insist on his point of order?
I do, Mr. Chairman.
The gentleman is recognized to explain his point of order concern.
The amendment would introduce material beyond the scope and purpose of the bill before us and therefore violates House Rule 16, Clause 7.
The gentleman is correct. The gentlewoman's amendment does not satisfy the subject matter and fundamental purpose test. Therefore, it is not germane and is out of order. Who seeks recognition?
Mr. Chairman,
Gentlelady from California is recognized.
I disagree with the finding, but having anticipated that that might be the finding, we have a redrafted provision that I believe would meet germaneness.
You have an amendment to
requirements.
desk?
I do.
Okay. Clerk will report. Point of order being reserved by the gentleman from Texas.
Reserved.
Clerk will report the amendment.
Amendment to the amendment in the nature.
Objection, the amendment will be considered as read. The gentlelady from California is recognized to explain the amendment.
Thank you, Mr. Chairman. Essentially, this strikes lines 3 through 9 in paragraph, in B, paragraph 5, and it strikes "and who are not described in subsection A2A have counsel to represent their legal proceedings," and inserts "have counsel appointed or provided by the Secretary at Government expense to represent them in immigration proceedings." I think this accomplishes, in a less fulsome way, the same goal as the prior amendment, which is that small children should not be appearing in immigration court, or frankly, any court, by themselves, facing a bunch of grown-ups who are talking about things they probably don't even understand. The idea that we could meet due process in such a setting in that way is preposterous, really. And there is no other circumstance in American jurisprudence where we would allow this. I mean, if a child is, in court, in state court, they have representation. And that's only, that makes sense, because we all know we have children, we have grandchildren. When you're a little guy, you don't necessarily understand all of this. And these are important issues. And many of these children, as we recognized when the committee did the trafficking bill, my recollection is it was unanimous, but it was certainly bipartisan. Many of these children are victims. They've been traumatized. And to have them appear in court by themselves and to try and cope with that is just unreasonable. So I recommend this amendment number 2 to solve that problem. And with that, Mr. Chairman.
The gentleman to yield.
I would be happy to yield, Mr.
Well, thank you for pressing the point, Ms. Lofgren. It strikes me that this is a really essential question for the United States House of Representatives Judiciary Committee. Not all of us, but the vast majority of us are lawyers, and we understand, all of us, the difference between somebody going to court alone, by himself or by herself, or going with a lawyer. And if you can't put yourself in the shoes of a 10-year-old kid who's probably terrified and shamed and embarrassed and anxious about the situation, put yourself in the shoes of our president, who has had hundreds of lawyers. He's got 34 felony convictions. He's an adjudicated sexual felon. He's been involved in thousands of cases, and he always had a lawyer. His right to counsel was always vindicated. But now we want to turn around and say a kid can appear before a federal judge or magistrate without a lawyer? Someone whose entire life is maybe flashing before their eyes at that moment? I mean, I just don't know how we do that as the House Judiciary Committee. I really hope that we haven't sunk to that point, and I thank you, Ms. Lofgren, for the time.
Thank you, Mr. Chairman, and I yield back.
Gentleman yields back. Gentleman from Texas recognized.
I thank the chairman. I oppose the amendment, and there's a number of reasons why. I want to rewind the clock for a second and go back some 20 years or 18 years or whatever. The gentlelady from California will remember better than I the exact year. But, when we did all this, I'm not even sure I remember the nature of the markup of the UAC provision. I was a lawyer on the Judiciary Committee, left, prosecutor, then I was back. So I got to remember which things happened when, but my recollection was that was then done separately and pushed into the bill as it was headed to the floor or something along those lines. But we could debate that, whether it was happened or not. My main point is, you fast forward just a few years, however the UAC provisions were adopted with respect to TVPRA, and you had President Obama in a letter to then Speaker Boehner on June 30th, 2014, outlining the severe problems with the UAC program and laying to bear those issues and asking for Congress to act, which the Republican-led Congress did act. The Senate did not, in providing the DHS Secretary, this is the language from President Obama, providing the DHS Secretary additional authority to exercise discretion in processing the return and removal of unaccompanied minor children from non-contiguous countries like Guatemala, Honduras, El Salvador, and trying to manage the very broken system that we created and that has now taken what began to be a problem that was being observed under President Obama, was gaining notoriety around the world and kids riding on top of train cars and all of the things that we saw that was horrific. And the extent to which the cartels were making large sums of money moving these children for profit. And then we had President Obama highlighting the issue, Congress then failing to actually respond to the issue. And we've been trying to solve the problem now for a while. And we did in H.R. 2. We are seeking to do it again now. And we note that in the last however many years, there's been significant people observing, and not even just on a partisan fashion, the extent to which our own federal government is essentially closing the loop on the child trafficking cycle and being part and parcel to the entire process, having created the system by which these children are exploited. So now we come to, all right, we have a system that our taxpayers are forced to pay for, to deal with all of this and to process people, which thank goodness this administration under these policies has diminished the numbers massively by virtue of carrying out the policies that we should carry out. And we're again trying to codify those so we can carry that forward. And we're being asked, taxpayers are being asked to foot the bill for that, to foot the bill for the proceedings, to then foot the bill for prosecution, of course. And then in this case, there are myriad NGOs and nonprofits that are funding the litigation defense for or cases for these individuals. And they have significant opportunities to avail themselves of those organizations. But the goal here ought to be to minimize and, in fact, to end the extent to which we have this problem by tightening the policies. That's the goal of the bill. That's the purpose of the bill. And I believe that at the end of the day, if you look at what we have, Section 292 of the Immigration Nationality Act states that in any removal proceedings before an immigration judge and any appeal proceedings before the Attorney General, the person concerned shall have the privilege of being represented by counsel. Now, that case obviously is at no expense to the government. The government is already having to spend an enormous amount of money to deal with this problem. We believe that it's certainly possible for the NGOs and pro bono counsel. Pro bono lawyers do, as the lawyers here in this room know, myriad hours, in fact, by requirement, typical of their law firms and their often engagement in the bar. They're engaged in tons of pro bono hours and can carry out that work to do this. American taxpayers shouldn't shoulder the burden of funding the expenses incurred by the government during immigration removal proceedings and the other side. And with that, I would yield back to the chairman.
Would the gentleman yield?
I yield back to the chairman.
I think the gentlelady from Washington's hand was up first.
Thank you, and I'll yield to the gentlelady from California just for a little bit, and then I have my own comments to make. Go ahead.
Thank you very much. I would just note that, I went down to the border during the Obama administration, and there were huge problems. The gentleman from Texas is correct, and there were policy issues that related to that. I'm not defending that. On the other hand, we have enough money to spend, $1 billion on a ballroom or many other things, but not a rather modest amount for small children who are in this country, who are in immigration court by themselves. That's unreasonable. Yeah. And I think I don't agree with everything that the Trump administration has done at the border, but I will say that I think there were failures during the Biden administration in their border policies that were on their way to being corrected. I don't think we should conflate those two as a reason to deny a little kid the chance to be represented in an adversarial proceeding in a court. To me, that's just unconscionable. And certainly all of the things that we're spending in Iran and on ballrooms and settlement funds for J6 rioters, I think we can afford to keep a little kid in court with somebody to stand up for him. And I thank the gentlelady for you.
Thank you so much to the gentlelady from California. I want to thank you for this amendment because I think it is very important and it goes to the core values of who we are as human beings, who we are as Americans. I have been to the court to witness a kid's docket, and I can tell you if you haven't been to one, you should go. It is stunningly horrific. I sat in a courtroom that was packed with probably 75, 100 kids as young as 3 years old, 4 years old. One of them had a stuffy with him that he was just sitting on the benches in the courtroom. And basically the judges give an 18-minute crash course in immigration law. And they say, you have the right to be represented by an attorney. You have the right to question the witnesses before you. They're talking to 3-year-olds and 4-year-olds. And these kids are sitting through hours-long proceedings without any counsel.
And how on earth is a 3-year-old or a 4-year-old or even a 10-year-old or a 12-year-old going to argue against, the judge will say to them, you have the right to question any witnesses that are testifying against you. How are they supposed to question anyone? How are they supposed to go up against an attorney that is skilled in immigration law, which is the most complicated form of law other than tax law in this country? And to watch these children sit through these proceedings without any counsel, and then to have to bear the brunt and the consequences of that, is actually why we do say right now, the law is that you have to provide counsel to the extent practicable. That is what is currently the policy. And I want to say that there are a lot of people we're not providing counsel for. What this bill does is it actually takes away even that language. And I think that if there's, you're asking about how we can ask taxpayers to pay for this. I actually think if we were to put a poll out there and ask the American public if they would rather spend money on this, or if they would rather spend money on the illegal war in Iran, or Trump's ballroom, or the reflecting pool that was done so badly because it was a no-contract bid, they would say this. I actually think the American people would want to make sure that children, young children, minors, are provided with counsel in these immigration proceedings. I think that is very much what people would want to spend money on, not on all of the things that we're spending money on. And just remember that this is in the context of the Republicans giving $210 billion, billion with a B, billion dollars to ICE and CBP, and now saying we are going to not only not provide attorneys, we're going to cancel the contracts. I mean, ORR has refused to pay legal services providers for their essential services, even though that money was approved. So I think that this is something where if we put this question out to the American public, they would all say, yes, we should pay for children, unaccompanied children, to have counsel. And that is exactly what Ms. Lofgren's amendment does. It's why I think it is so important that we stand up for our values as Americans and that we approve this amendment.
The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. It's hard to imagine we're sitting here and having discussions about giving children legal representation when they're subject to deportation. They have, a hearing is supposed to be confrontational between two sides or adversarial. And have a child without representation against an attorney is not a fair process. And they do have a right to a hearing. You all understand that. And at the hearing, there needs to be fairness. And the fact that we're discussing that is just hard to fathom. And that Mr. Raskin and Ms. Lofgren's first proposals were ruled out of order. This whole committee's out of order when they can't recognize the fact that children should have help at the council. And they can't make their own decisions, and they don't know how to deal with the system. It's unfair. It's something America doesn't countenance. We've always been the land that saw fairness as part of our due process and justice system. This is the opposite of it. We have it in our laws to require children to have legal representation. What's the name of this law? Anyway, there's several laws that do give representation, or say you should try to get it. The Trafficking Victims Protection Reauthorization Act of 2008, requirement that the ORR ensure counsel for unaccompanied children to the greatest extent practicable. Trump administration has appealed that ruling. They want nothing, the Trump administration. And you got to realize where this is coming from Donald Trump. This is what he wants. He wants to deport as many people as possible. That's the message he gave to the Department of Homeland Security, is deport, and Stephen Miller gave them a head count. They wanted, I think, 3,000 people a month or something like that. And they have to meet their head count. And they go out and they do it, and they get people, and they do it sometimes illegally, and they do it. Sometimes they kill people because they make mistakes, and they don't really understand what they're doing in the law. The President of the United States needs to resign. He's doing so many just unimaginable things to this country, and to justice, to due process. If you go overseas, what people say they value about the United States is our system of justice and due process. We don't have it here anymore. He appoints his own people to the different committees that regulate the building of the ballroom, which is unnecessary. He's deporting all the people who'd be waiters and cooks. Who's going to work there for 1,000 people? They're not going to have them. Every great society has people at the bottom who do work, and they're necessary. And we're deporting them. We're deporting people who do work and keep our communities active. They've deported a lot of people in Memphis. They've come there with their safe task force. It hasn't helped reduce crime. Crime, just like in Washington, is about the same. He doesn't even know about the killings. He mentioned one time, oh, there was a killing over there in Lafayette Square. That was the woman and National Guardsman that was killed because Trump made them come here. He's responsible for that death. He's responsible for all those deaths because he's put people out there and created a lot of hate. Now he's talking about putting an 8-foot-high fence around Lafayette Square. Lafayette Square, where people go and sit and talk and have discussion, he's going to put an 8-foot-high fence. I guess there'll be a gate that gets you open and lets you out. Maybe they just want to swing the gate and lock people in if they choose to do that. That's insane. It's like going in front of the church and holding the Bible upside down and claiming you're doing something in front of the church. The most a-religious, sacrilegious person ever to be in our government, probably. He golfs on Easter. He doesn't go to church. He doesn't believe in religion. He doesn't believe in doing it to others as you do unto yourself. He doesn't know any of the good principles that come out of it about the person that's naked and giving him clothes, the person's hungry and feeding him. He doesn't know Matthew whatsoever. He knows Corinthians 2. What a joke. He doesn't know jack about religion. He's irreligious and he's terrible and his values doesn't exist. It's all about him. It's a centered one person, narcissistic grifter. And that's who's guarding this country and that's who's put these laws in effect. He doesn't want anybody to have counsel except himself. He wants Roy Cohn and Roy Cohn-spirited people to give him counsel. And he's got one with Stephen Miller. He's got one with the new guy he's got in to be head of the Department of Justice, quote unquote, a small J. Roy Cohn taught him, never admit you're wrong. Never back down. Never admit you're wrong. Roy Cohn was evil and one of the worst people ever on this earth, and he's the mentor of the President of the United States. You get it? I yield back.
Gentleman yields back. Gentleman from Georgia is recognized.
Thank you. I rise in support of the Lofgren Amendment. You know, a few weeks ago, it was Donald Trump's birthday, and to commemorate his birthday, he had a cage match on the grounds of the White House. And a lot of my friends on the other side of the aisle were there to witness a number of contestants trying to beat the Pope out of their opponent, and then stand up and talk about former First Lady Michelle Obama after that. But I mentioned the cage match because I wonder if my friends on the other side of the aisle would go to the White House for a cage match that featured a full-grown male lion versus a newborn kitten. You know, I wonder if you would find enjoyment in that kind of a match. But that is exactly what happens in immigration court for minors and for little babies and little children, preschoolers. So I rise in support of this amendment because the underlying bill strips all legal counsel programs for children and declares that the government should never pay for lawyers for children, even if by some miracle these children can find and pay for lawyers on their own. The underlying bill gives them at most 2 weeks before their immigration hearing, which is not nearly enough time. I strongly support Representative Lofgren's amendment for the same reasons that I was an original co-sponsor on her Fair Day in Court for Kids Act. Like little toddlers are showing up in court unable to speak English, often traumatized, and perhaps clutching their doll or stuffed animal. Their feet may barely touch the floor when they sit down, as they stare silently at a judge in a black robe speaking a language they do not understand. They are scared and overwhelmed and cannot possibly navigate complex legal proceedings by themselves. They are just like that little newborn kitten. Yet, we have set them up to be alone against a government-trained, full-grown lion, a lawyer, to decide if they should be deported back to countries where they face persecution, trafficking, or death. Do we really think that a toddler should be able to learn immigration law? The numbers show how dire the consequences are for children who cannot obtain counsel. Immigration judges are nearly 100 times more likely to grant relief to unaccompanied children who have a lawyer, and that makes sense. We provide counsel to adults who are charged with federal crimes because we want to ensure their fundamental right to a fair trial. If a grown adult needs a lawyer for a fair trial, it's obvious that a toddler does as well. Children lack the capacity, emotional maturity, and legal knowledge to understand their rights, gather necessary evidence, and formulate legal claims. Yet we just pretend that they do. It's heartbreaking, it's unjust, it's unfair, it's cruel. It's not for the children. If not for the children, at least vote for Ms. Lofgren's amendment for the immigration courts and the immigration judges. A courtroom cannot function when one side is represented by a literal baby. Judges cannot oversee cases efficiently, and the court system becomes destabilized, clunky, time suck. Having unrepresented children in court hearings is bad for everyone, and I strongly urge my colleagues to support this amendment as well, because we cannot expect babies to serve as their own lawyers. I mean, if you get satisfaction from watching a cage match with a kitten and a full-grown male lion, then vote no on this amendment. If you think that there's no utility or usefulness in watching such a display, then vote yes for this amendment, and I yield back.
Gentleman yields back. Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. First of all, I've got to say that I'm concerned that so many of our members, I think more on your side of the aisle, Mr. Chairman, are not present here. In fact, I want to commend the Democrats for staying here for this important legislation. I'm just concerned that some people are going to come back and then just vote in a way they don't even really understand what we're talking about. This language that's currently in the bill repeals a critical part of the William Wilberforce Trafficking Victims Protection Act. Trafficking victims, that's what's being repealed by this legislation. Minors, kids who are coming in to court to be heard about a claim of human trafficking or gang violence or government violence now go by themselves. How many of us would send one of our kids, an 8-year-old kid, a 10-year-old kid, to the movies by themselves? How many would send a kid to the doctor by themselves? How many of us would send a kid to the dentist by themselves? Maybe Mr. Van Drew, he probably knows a dentist, or I'm sure they'd be in good hands there. But you get my point. I don't think we send our kids to the store by ourselves. And yet, now we want to say that at a time when, as Ms. Jayapal's pointed out, we're spending billions of dollars, $130 billion already on an illegal, unauthorized, unconstitutional, disastrous war in the Middle East. $1 billion they want to rebuild the bulldozed White House, which was done illegally. Or just take the relatively modest example of just $15 or $20 million for the president to play around with the color of the water in the reflecting pool. During that time, we're going to strip from children the right to have a lawyer with them when their whole future is at stake? How much money do we think we're going to save doing that? I don't know if anybody has quantified it. Is it $1 million? Is it $400,000? So let's say one of these kids, imagine that one of these kids actually has a valid claim okay? If everybody can engage in that empathic hypothetical leap. Imagine one of these kids has a valid claim. Say that their family has been targeted by the government because they belong to the wrong political party. And that's why the family sent them to America. Imagine that it's a teenage boy, perhaps the most suspect demographic category in the world, a teenage boy who is running away from a gang that's insisting he join the gang. And he wants to come here to the country, to the land of the free and the home of the brave. Maybe he saw the Statue of Liberty. Imagine the core paradigm target of the Human Trafficking Act, which is being repealed by this language. So you've got a 12 or 13-year-old girl who's being subjected to human trafficking, threats and violence, intimidation. Maybe they don't even speak the language, but maybe they actually have a valid claim to asylum. And now we've reached the point where we're going to strip them of a lawyer. Under administration headed up by a president who has had literally hundreds of lawyers. It doesn't go anywhere without a lawyer. We know the names of his lawyers. Sidney Powell, Rudy Giuliani. Todd Blanche declared, I'm his lawyer the other day. That's why he shouldn't be attorney general. He should just go back to being in one of Donald Trump's battalion of lawyers. How about we show the tiniest bit of compassion? What America was made for. That's what our country is. For the tired and the poor, the huddled masses yearning to breathe free. Have we forgotten all of that? Well, so, a whole bunch of people are going to come into the room and they're just going to go ahead and vote no because somebody's going to tell them to vote no. I warn them, they do that at their own political peril when America finds out what's going on here right now. I find it absolutely shocking and mesmerizing that they would walk into this position, and I urge everybody to rethink it. And I want to thank Ms. Lofgren for spotting this subtle change in the language. And they say, oh, well, just get pro bono lawyers. Yeah, the ones that still exist because they haven't been shaken down by the president for hundreds of millions of dollars of free pro bono assistance because he issued an executive order against their law firms. I yield back.
Gentleman yields back to you.
Mr. Chairman.
Gentleman from Texas recognized.
Yeah, just a few things to respond to.
I will claim the time and yield to the gentleman from Texas.
No, thank you. A few things to respond to. First of all, when we talk about the number of NGOs and the amount of people that are out there with money that are funding vast armies of pro bono lawyers in this case, they all receive significant taxpayer funds. All of them, bucket loads. Catholic Charities alone responsible for resettling 600,000 aliens in 2021. Catholic Charities usually receives $1.4 to $3.7 million from the federal government each year. In 2023, it received $18.8 million. The Hebrew Immigrant Aid Society in 2024 received $113 million from the federal government in part to support the resettlement of aliens in the American interior. The Lutheran Immigration Refugee Service, 95% of its funding comes from the government. And all of these organizations are funding enormous armies of lawyers on a pro bono basis. There are literally billions of dollars going out in taxpayer funds for this very purpose. And it's going out through NGOs. And it's literally documented out there. And when we talk about the actual numbers, I have the numbers from 2026 in terms of what we're dealing with in terms of relief granted for the children in question. And I said, well, I don't want to look at 2026 because it might be said, well, the Trump administration is being too harsh. So I asked for the information from 2024 to go back to the Biden information. And I look at the data from second quarter 2024, the last year of the Biden administration. Of the 40,000 pending UAC cases, 9,100 decisions at the time, 118 had relief granted. 118 out of the 9,186. The rest were dismissals, terminations, removals, voluntary departures. And my point of all that is not to say that there's not a case that shouldn't have a good, competent lawyer adjudicating the case. I believe that pro bono lawyers are doing that, and I believe that they're getting that. It is to say that we have created the problem. We, Congress, have created the problem with the legislation, and then the administration the previous administration in particular. But with all due respect, President Obama at least recognized the problem and asked for it to be fixed. Literally sent us a letter begging us to fix the problem that is causing these children to be put in. We talk about we wouldn't put our children out to go to the store by themselves. Well, we sure as hell will put them out to be trafficked by cartels by themselves, to be sent across the border, to be abused by themselves, because we create the very climate that makes it occur. This is what is so galling about this. These children will get representation. I assure you, if you look at the money that is flowing to these NGOs, literally billions of dollars of taxpayer money. They are getting the taxpayer funds. And what we're saying here is that we should be right now minimizing these cases. That is the purpose of this bill. That is the purpose of moving forward to codify what the president is doing, because this administration finally is trying to bring some sanity to the border. And with that, I yield back to the chairman.
Could I ask you a question?
I would ask the gentleman the question, if I'm not mistaken, didn't the Biden administration during the 4 years that they allowed approximately 10 million illegal migrants to enter the country, didn't they lose track of kids?
They lost track of tens of thousands of kids, depending on the numbers you look at, and Tom Homan has been very clear about what they've been doing and trying to track down those children. And they literally couldn't tell us where 350,000 kids were at one point. We started narrowing it down, and there are still tens of thousands we haven't locked down.
And the goal of this legislation is to stop that from happening.
Correct.
They're giving us a lecture on compassion. I don't see the compassion in that.
I do not either.
I don't see the compassion in those thousands of people we saw under, what was it, the Del Rio Bridge?
Yes.
Day after day after day, living in those conditions, and then being put in these temporary shelters. I mean, where's the compassion in that? Or what happened in Eagle Pass, what we saw there on the trip? We saw that for 4 years. This bill's designed to stop that. But that's the problem. The Democrats, they don't want to stop that. They want that to continue.
And in my first year in Congress, and I'd known this before, being a Texan, and I was familiar with it working with law enforcement. I was down at the border, and I still have a picture of this little girl, and I never did anything with it because I didn't want her picture out there, of a phone number on her arm, which is all she had. And talking to the two fellas in front of her about her status and what they knew about her, because she was not really talking to folks, and what they knew about it, how she'd been abused on the trail. And they walked through the extent to which this beautiful little 7 or 8 year old girl was abused on that trail all the way up through the process by a situation we created, by a situation that we allowed to occur and that we empowered cartels and evil actors to carry out. The reason that I feel so strongly about proceeding with this legislation to curtail the problem of the abuse under UACs, under the catch and release Flores, the abuse of asylum and parole, is to stop the madness. This president's doing it. We should codify it. I yield back.
Gentleman yields back. The gentlelady from, I think, California, and then we'll come to Vermont.
Thank you, Mr. Chair. I just want to say this is incredibly dystopian to have this conversation about young children, unaccompanied minors, not being able to have representation. I mean, we've had a conversation about money, all this money, what the taxpayers are, I don't know. But, you know, this president has contributed $11 trillion to the debt. And I don't see anybody up in arms talking about that. This president asked us to cut $1 trillion in health care. I'm sure all of us have constituents in our districts that are going to be hurt because of that. I don't see anybody from the other side up in arms about that. And as it relates to these children, you know, I have been to the courts, and going into these courtrooms for these hearings, it is a daunting, scary process if you're an adult. If you're an adult with an attorney. It's even worse if you're an adult and you're pro per representing yourself. And now you're saying children to represent themselves? It actually boggles the mind. In some instances, what I've seen, there are children where language is a barrier and they don't really understand what they're saying. They're hearing words where they don't understand. In some instances, you have children that have developmental disabilities. They're on the spectrum. They're not getting additional help or support for that. And now you have courtrooms that are so overwhelmed that the judges are restricting continuances, and sometimes they are noticing hearings with less than 24 hours advance. So that's even hard for an adult with an attorney to manage, because an attorney probably has more than just that one client, and just all of the machinations to get it together to go before a judge. And you're asking for all of that to be managed by a minor who might be on the spectrum, a minor who might not understand everything, a minor who might have English as a second language, and a minor who is just scared out of their wits. And there's no context about the backstory for that child, how that child got here, what that child is running from, what that child may face if they're deported. And all of those things must be taken into consideration. The courtrooms that I've been in for proceedings, an attorney would bring all of those things up so that the judge could make a coherent decision based on all of the information provided. See, the attorney is the advocate, and you're essentially saying you want a child to go in there without an advocate. And last year, actually, Trump partially terminated the program that would allow children to be represented. So then folks had to file an injunction. And so all of these legal service providers that you all are talking about, you know, they had waiting lists upon waiting lists of kids that they couldn't help because of all of these shenanigans with this administration that you all are trying to co-sign.
And when an ignition starts, we're getting more resources to the fire quickly. And while government and first responders have an important responsibility to prepare, and we are, every Californian has a role to play and the power to protect themselves and their family during these types of events. Since 2021,
child that you're throwing in a courtroom without an advocate, without any kind of representation, you're doing incredible harm to. And you're not going to recount the story of that child being deported and then raped or murdered or killed or dismembered because they went back into a really terrible situation. You're not going to put that child's name on your note card to read out into the record. So that's why you should be voting yes on this amendment. And with that, I yield back.
Gentlelady yields back. The gentlelady from Vermont's recognized.
Thank you, Mr. Chair. I associate myself with the remarks of the member from California and also strongly support the Lofgren Amendment. So to level set here, what we're talking about is that the bill that the Republicans are trying to push through this committee right now would end any government-sponsored counsel for unaccompanied children. Children. It puts the onus on kids to find and pay for their own counsel in court, which of course is going to force many children to not be represented at all. And as the member from California said earlier, Ms. Lofgren, there's no other area of jurisprudence where unaccompanied minors would have to appear without legal counsel in front of a federal judge or a magistrate. So the only way I think you can get to this position is if you don't think that these children or these unaccompanied minors are worthy of basic human dignity, that you are putting them in some other file in your head, that there are somehow worthy children that are entitled to counsel in front of a judge, and then there are unworthy children. And I can say as a parent of a 16-year-old and an 18-year-old, I wouldn't even want those children who have a highly educated mom who serves in Congress to be in front of a judge without counsel. So to be thinking about kids, as you said, the member from Washington, as young as 4, 5, 6 years old, sitting in front of a judge, having the judge talk about what the proceedings are going to entail. The only way that you can be okay with that is if you don't believe those kids are entitled to basic human dignity. So we can talk about many other provisions of this bill. This one, to me, is just absolutely shocking that we can't all agree on this. That there should be a line for all of us who say we care deeply about children in this country, that we would send kids into a courtroom and claim somehow we don't have the money to pay for this, where we've all talked about all the ways in which this administration is wasting taxpayer money. We haven't even talked about the Qatari jet that has sent us back hundreds of millions of dollars that the president can't even use at this point because it's not safe. So it's not a question of money and when we have the money. It's where the money is being spent. And I can tell you, I agree with what a member on my side said earlier. If it were between spending money on those things or actually spending money to make sure that children have representation in court, I think I know where most Americans would come down. And I yield back.
Gentleman yields back. The gentleman from Illinois is recognized.
Thank you, Mr. Chairman. I move to strike the last word. I rise in support of this amendment for reasons that my colleagues have clearly and unequivocally laid out. But I also wish to speak to the underlying bill, because here we go again, marking up a bill by the most powerful to inflict violence on the most vulnerable. And once again, this markup is just a show, because this disgraceful piece of legislation is so extreme that it doesn't even have the votes in the anti-immigrant Republican Party. And that's why we didn't mark up this bill until now. The Speaker and the Chairman know it doesn't have the votes. So the folding caucus threw a longer tantrum on the rule this time, and now we all have to listen to the Republicans pretend that they're going to pass this garbage. But even if this markup is a joke, the policies in this bill are not. They reflect the shameless cruelty of the Trump, Miller, and their mass death squads, and what they're inflicting on our communities. It's real, and it's paid for by our tax dollars. They're executing innocent people on our streets. They're racially profiling people. It happened just 3 days ago in my district on a U.S. citizen. They're breaking up into people's homes without a warrant, and the Republicans gave them $240 billion to do it. Think about that. Working people in this country struggle to put food on the table, buy a house, and pay for health care. Many don't even make a living wage. And the people elected to represent them spend $240 billion of their tax dollars to pay a bunch of racist thugs to terrorize random people on the street the way they do in my district every day. Not on health care, not on housing, not on nutrition assistance, not on public schools, not on child or elder care. They're paying sadistic criminals like David Brulette, who murdered John Sebastian Duran Guerrero in Maine, or Charles Exum, who shot Marimar Martinez, my constituent, 5 times in Chicago. These are the violent mercenaries who brag about shooting and murdering people. And because the Republican Party has no purpose other than to persecute immigrants, give tax cuts to the rich, and destroy democracy, they have no choice but to double down on the cruelty. And that's why this bill, they want to inflict more violence on children, on people who accidentally overstay a visa, on people who are fleeing war, natural disasters, or persecution in their countries of origin. It's especially sickening that in many cases, people are forced to leave their countries partly because of our policies of our government. We cut off food, medicine, and energy to civilian populations, as in Syria and Venezuela, Iran and Cuba. We fund war and mass destruction like in Gaza and Iran. We overthrow governments in occupied countries like Venezuela. And then, as innocent people flee the only homes they've ever known, we deny them asylum. We criminalize them. And in some cases, we kill them. And while our constituents struggle to make ends meet, because these same politicians gutted their healthcare, education, and nutrition assistance to fund ICE, this is not a redeemable piece of legislation, which could be improved with a few tweaks here and there, or by going back to the status quo, even though there are valiant efforts to try to do that. And this is not a redeemable political vision. This is a vision of persecution and exploitation, of pitting working people across borders against each other, while the rich and powerful rob them over and over again. There is a better way. I saw it earlier today when I stood with colleagues, advocates, and union leaders advocating for a discharge petition to bring the Dream and Promise Act for some sensible immigration reform that Americans support. Thank you. I yield back.
Gentleman yields back. The question occurs. The gentleman from New York is recognized.
Mr. Chairman, I yield to the ranking member.
Ranking member is recognized.
And I want to thank the distinguished gentleman from New York for yielding. This thing is actually even worse than I thought now that I'm able to do some down and dirty legal research on it. In March of last year, the Trump administration abruptly cut off all funding for the nationwide legal services programs that serve unaccompanied children, the Unaccompanied Children's Program. That cancellation order was not explained. It was not justified. There was no attempt to make it consistent with the law, which requires it. And the consequences were immediate. There were 26,000 unaccompanied kids across the country who faced losing an attorney under the dreadful circumstances all of my colleagues have just described so eloquently. There was a group, and I'm not familiar with the group, but I certainly applaud them, COSEPA versus HHS, which brought a lawsuit on behalf of 11 legal services groups and co-counseled with the Justice Action Center in Gibson Dunn and the Immigrant Defenders Law Center to challenge this totally unprecedented and unlawful termination in federal court, U.S. District Court in California. And a federal judge issued a temporary restraining order, then issued a preliminary injunction, and found that the government's actions cannot stand, totally outside of the law. The government has tried multiple times to overturn these rulings, and the Ninth Circuit Court of Appeals has repeatedly rejected it. Okay, so they weren't able to get their way and wipe out legal representation for kids just by cutting off all the money, because it's very clear that that was contrary to law. So now they want to sneak it through this legislation in a few words. I see in parentheses, first it says to get them legal representation to the greatest extent practicable, and then in parentheses, at no expense to the government. Those are the critical words, at no expense to the government. Now, I come back to my friend from Texas, who I must say I'm going to miss so much when you leave, Mr. Roy, and it's always a pleasure to get to work with you on this stuff. I certainly did not understand the full extent of this. I'm not sure you did, because your argument to me seemed to be, we don't need government funding because you've got these not-for-profit groups that will pick up the slack. But the whole point of that parenthetical is to strike at the government funding that those not-for-profits get, which allow them to send lawyers in. They just want to get rid of it. And in fact, there's not a lot written about this, but I found something from the McDowell Social Justice Center.org. Unaccompanied children have a legal right to counsel. The government cannot ignore the Trafficking Victims Protection Act. And then in this, what it says is what's actually going on is that there's an attempt to privatize the whole thing. Well, what do you know? There's a profit motive at the center of this particular effort to strip this basic right that kids and all human beings have in court. And what does it say? As reported by The Lever, it's a journal I admittedly don't know, I don't recognize it. As reported by The Lever in its investigation, President Trump is poised to privatize legal aid for migrant children, seeking to privatize all legal representation for unaccompanied children. So the move likely shifts these services to a for-profit ICE contractor and imposes dangerous requirements, replaces in-person services with virtual videos, slashes funding through fixed-fee contracts designed for private vendors, and results in significantly fewer children receiving any representation at all. You know what it reminds me of? It reminds me of what the federal district judge down in Florida just found about the completely illegal, outrageous, and discredited $1.8 billion political slush fund they tried to set up for the Proud Boys and the Oath Keepers, which even Todd Blanchard now says is not moving forward, but we need to put that into law for obvious reasons. He says it's not moving forward now, but the judge said that was a collusive litigation. You were on both sides of the issue. And that's exactly what they want to do here. They want to abolish a real lawyer for these kids and put in a for-profit ICE contractor. So you basically have the government being represented on both sides of the issues, and they would impose that on little children whose entire lives are at stake. That is wrong. And we should vote that down today unanimously in this committee. Thank you, and I yield back.
I simply say that the ranking member's observations are obviously correct, and I urge that this amendment be adopted. I yield back.
Gentleman yields back. The question now occurs on the amendment offered by the gentlelady from California, I believe. All those in favor say aye.
Aye.
Those opposed, no. No. In opinion of the chair, the noes have it, and the amendment is not agreed to.
Seeking a roll call vote, Mr. Chair.
Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Ms. Hageman? Ms. Leah Florida? Ms. Leah Florida votes no. Mr. Hunt? Mr. Fry? Mr. Kiley? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Schmidt? Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Lee of Pennsylvania? Mr. Onder? Mr. Onder votes no. Mr. Moore? Mr. Moore votes no. Mr. Klein? Mr. Klein votes no. Ms. Lee of Pennsylvania? Ms. Lee of Pennsylvania votes yes. Mr. McClintock votes no. Mr. Issa votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Gale, you are not recorded. Mr. Gale votes no. Ms. Hageman, you are not recorded. Ms. Hageman votes no. Mr. Chairman, there are 12 ayes and 13 noes.
The amendment is not agreed to. Gentlelady from Washington.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Texas.
Amendment to the amendment in the nature of a substitute to H.R. 9773, offered by Ms. Jayapal of Washington. Page 53.
Without objection, the amendment will be considered as read. The gentlelady from Washington is recognized to explain the amendment.
Thank you, Mr. Chairman. In a normal world, I would say this would be a simple bipartisan amendment. But I certainly hope that's the case, but not much seems normal, and given the conversation over the last several hours, I have no doubt that my colleagues will raise objections. This title of the Section 4 of the bill claims that the legislation is about, quote, uniting families. However, the bill as written allows for the detention of entire families without regard to whether any of the children are U.S. citizens. As the majority knows, U.S. citizens cannot be detained under current law. That is why my amendment simply clarifies that families with U.S. citizen children may not be detained under this bill. If the majority claims that's not what they meant and that's not what the bill does, great, we've got the solution. The bill language is poorly drafted, and a plain reading of it explicitly allows for families with U.S. citizen children to be detained and/or for immigrants to be indefinitely in family detention facilities separated from their U.S. citizen children. 5.5 million U.S. citizen children live in households with at least one undocumented person. Just under 2 million U.S. citizen children live with two undocumented parents. This bill would authorize the Secretary of Homeland Security to throw millions of children into immigration detention if ICE puts their parents into removal proceedings. Remember, this title is also retroactive, throwing families into limbo even if they lived here for years. The Supreme Court recently reaffirmed the plain meaning of the 14th Amendment that those born in the United States are U.S. citizens, despite Trump's obsession with trying to change it. Now, I want to be very clear. Family detention is barbaric, and it is a traumatizing process to which no child, regardless of citizenship, should be subjected. The harm of detaining children is clear. According to the American Academy of Pediatrics, there is no evidence that any amount of time in detention is, quote, safe for children. Even In fact, even short periods of detention can cause psychological trauma and long-term mental health risks for children, end quote. According to a physician and psychiatrist who investigated the family detention facilities for the Department of Homeland Security's Office of Civil Rights and Civil Liberties, quote, shorter lengths of detention did not sufficiently mitigate the harmful conditions that we observed and their deleterious consequences. Most of the harms we documented were in families detained less than 20 days, end quote. We have seen the effects of detention on children under the Trump administration. Children detained in the South Texas Family Detention Center in Dilley, Texas, have gotten sick and received improper medical care. They have received inedible food. They have become depressed. A 13-year-old girl attempted suicide with a plastic knife and hitting her head repeatedly. The idea that my Republican colleagues would not only endorse these horrors, but actively seek to impose them on more children, including U.S. citizens, is grotesque. But sadly, unless there is a drafting error, that is exactly what this bill does. And before my colleagues say that's not what was meant and DHS doesn't detain U.S. citizens, we know that's all false. Take the case of Jackie Merlos. Immigration officers arrested Jackie and her family, including her 4 U.S. citizen children, at Peace Arch State Park, where they went to see her sister, who lives just over the border in Canada. When Jackie went to hug her sister, agents arrested the whole family, accused them of attempted alien smuggling, and took everyone but the sister, who remained across the border in Canada, into custody. The whole family remained in custody for weeks, and DHS was working to get passports for the U.S. citizen children so they could deport the entire family. Fortunately, family members and friends were able to get the children out of custody, but ICE detained Jackie for several months until the case against her was thrown out. Jackie's family is not the only one to experience this. We have heard countless stories from across the country of U.S. citizen children being detained and even deported, including multiple children with cancer. And with this bill, Republicans want to subject even more families to this horror. My amendment would make a horrific bill just a little bit better by preventing U.S. citizen children from experiencing this nightmare. And again, I would just call on my colleagues across the aisle to have a little bit of humanity here and also to follow the law. You cannot detain U.S. citizens. I hope my colleagues will join me in protecting U.S. citizen children and accept this common sense amendment. I yield back.
Gentlelady yields back. Gentleman from Texas withdraws his point of order and is recognized.
Thank the chairman. I guess my colleagues on the other side of the aisle are for family separation now, because that's effectively what they're calling for. The purpose here is to make sure that we keep families together. That's the point. When you have someone who came here illegally, you have illegal alien parents, and they have a child, for the vast majority of cases would be an illegal alien child. To the extent that it is not an illegal alien child and it is a alleged or actual citizen child, it is almost certainly often going to be the case that it is the product of so-called birthright citizenship, notwithstanding the Supreme Court's erroneous ruling. The reality is that's going to be almost certainly the case in a number of these situations of the hypothetical put forward. My point is just this. We have already, by the way, in the funding mechanism in the OBBB, we have this exact language in place, very specifically, and this would be in alignment with that, and it is purposeful to hold families together. That's the point. We are trying to make assessments, and by the way, if we embrace the policies we're talking about, we're decreasing the pressure at the border, we're taking power away from the cartels, we are trying to make it to where you can manage cases, which the evidence is now bearing out. We're putting more immigration judges in place. We're processing these claims and cases faster. We're making decisions where in the limited cases, as the data also is evidenced under both presidents, under Biden and President Trump, in the cases of asylum, when there's a tiny fraction that are granted asylum or a tiny fraction that are on the unaccompanied alien children who can stay, et cetera. We're processing them quicker, so the backload is reduced. That is the point. And so rather than the current system, which is everybody come in, everybody be able to claim asylum, everybody be able to get categorically paroled, everybody get released, hope you show up one day, and you can't, by the way, deal with the situation of a family unit, you're stuck in this impossible decision where it's either flout the law and hold the family unit together or release the entire family unit. You can't manage the problem. All this would do is say, look, keep the family together. And if it's a citizen child by virtue of birthright citizenship or otherwise, it is better for the family that they be together and while we're adjudicating whatever claim that they allege to have, which, by the way, is statistically improbable based on all of the evidence we have, that it would be highly likely that they don't have a claim. But to the extent they do have a claim, that it would be able to be adjudicated under asylum, whether it's parole or whatever we might be dealing with, and it is better served if you do it as a family unit. That's the point. We believe this is the humane thing to do. We believe this is the right thing to do. Keep people together, adjudicate the claim, and then make the case going forward as a family. When you separate them, when you empower cartels to intervene, when you create perverse incentives to make false claims about citizenship or not, when you make incentives to be able to claim children and be able to use them for fake family units and so forth, we think that is harming children, harming aliens, empowering cartels, undermining our security, and so forth. So for that reason, I oppose the amendment. I yield back to the chairman.
Would the gentleman from Texas yield?
I'll recognize Mr. Raskin to yield to you.
Thank you.
I yield to the gentlelady from Washington, but save me some time because I got some
Okay,
stuff.
you got it. I just wanted to respond to the gentleman from Texas's comments because we are explicitly fixing an error in your bill that says that either you have to detain U.S. citizen children with their families or you have to separate them. We are saying, no, let's exempt the families who have U.S. citizen children so that you can keep families together. This is all about keeping families together, uniting families, which is in the title of your bill. And so I want to clarify that if you support not separating families, you should support this amendment because it fixes the language in your bill that essentially says you can detain entire family units or with U.S. citizen children, or you separate them. That's what your bill does, and I'll yield back to the ranking member.
Now, I'm glad you clarified that. It's an essential point. But, you know, we've now reached a moment, I think, that really the whole country's got to pay attention to, because Thomas Jefferson was someone who warned that if the government was to be allowed to violate the rights of non-citizens, it would inevitably come to violate the rights of citizens as well. And this particular language is a very vivid demonstration of that principle. Why is that? Because in the United States of America, U.S. citizens cannot be held unless they are convicted of a crime or unless they're charged with a crime. That's what habeas corpus is all about. If you're being held by the government and you're a U.S. citizen, you've got the right to get out. The government can't hold you. The only two exceptions to that I'm aware of, I think, are enemy combatants in war, if they constitute a threat to society. And in certain cases, I remember, and somebody maybe can look this up, there were certain cases where U.S. citizens who were material witnesses to a crime could be held even without charges until they testified or until they gave a report. But in any event, none of that has anything to do with what's going on here. This legislation, which the gentlelady from Washington is trying to correct with her excellent amendment, this legislation would actually say that citizens of the United States who happen to be minors can be held against all due process, against habeas corpus, and I take it indefinitely. Am I right about that? Can we get that on the record, Ms. Jayapal? They could be held indefinitely as U.S. citizens under the language of this bill.
That's correct.
Okay, so It's an old story. Thomas Jefferson warned about this during the Alien and Sedition Acts. He said, if we are willing to sacrifice and surrender the rights of non-citizens who are being rounded up and arrested and deported without any due process at all, it is going to come back to haunt us. And we know that they're U.S. citizens, and one of them was in my district who've been held for many days in ICE deportation or detention facilities. That's happened to lots of U.S. citizens. Somebody please find me the numbers on that. We know there's lots of citizens, but this is an attempt to codify it and to say that U.S. citizen children can be held indefinitely by Homeland Security and ICE because one of their parents is being held, and we'll just sweep in the whole family. And they rejected, I believe it was Ms. Ballant's amendment, to deny the right of family detention. I can't remember if that one was yours. It was Ms. Jayapal's amendment. They rejected that, so now they want to sweep the whole family in, whether you're a non-citizen or a citizen. Look how far we have come. And this is an old story. It's an old story, not with democracies. Democracies like to respect everybody's rights, but it's an old story with empires. Empires would extend their reach over lots and lots of land. And so you had to be a citizen and not a subject in order to exercise rights. But inevitably, because of imperial practices, the rights of citizens would be sacrificed and denigrated and diluted, just like the rights of the non-citizens. Let's get back on the path towards being a democratic republic and not acting like an empire with paramilitary forces that kill U.S. citizens without warrant, that kill immigrants without any reason. I yield back.
Gentleman yields back. The question occurs on the amendment offered by gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it.
All right, I'm going to have to ask for a recorded vote on that call.
Being requested, the clerk will now call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Ms. Hageman? Ms. Leah Florida? Ms. Leah Florida votes no. Mr. Hunt? Mr. Fry? Mr. Kiley? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Schmidt? Mr. Gill? Mr. Baumgartner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes yes. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Lee of Pennsylvania? Mr. Moore votes no. Mr. Issa? Mr. Issa votes no. Mr. Harris? Mr. Harris votes no. Ms. Lee of Pennsylvania, you are not recorded. Ms. Lee of Pennsylvania votes yes. Mr. McClintock? Mr. McClintock votes no. Ms. Kamlager-Dove votes yes. Mr. Onder? Mr. Onder votes no. Mr. Gill, you're not recorded. Mr. Gill votes no. Mr. Garthman votes no. Mr. Van Drew, you are not recorded. Mr. Van Drew votes no.
Clerk report.
Mr. Chairman, there are 13 ayes and 13 noes.
The amendment is not agreed to. The chair now recognizes the gentleman from Wisconsin, Mr. Grothman.
I'm sorry, I've had other committee hearings today, but I hear some things I want to clarify.
Go right ahead.
First of all, there are people who say that we're only going to remove the people from this country who are the worst people. If we're going to have an immigration law in this country, and we're very, very generous with people from other countries, every year about 800,000 people come here and are naturalized. 800,000. We're at a point where 1 out of 6 people in America was born in another country. That's more than even was in the late 1800s. So we're very generous, but I don't know who thought up this idea that if you come here and you shouldn't be here, the only people we're going to remove are people who are like committing murders. We'll remove them too, but if we're going to have an immigration law, we can't just say anybody comes here. So we should be removing those people. Then I don't know if this bill is going to get to the floor, but if it gets to the floor, I feel in the interest of trying to hold families together, there ought to be a provision in which our immigration laws do not allow families to break up because they come here. In other words, if there's a woman from, I don't know, Honduras, and she comes here with her child, and the father of the child is still staying in Honduras, we shouldn't allow it to happen, right? In this country, if you go through a divorce proceeding, you may have an order that, you know, the two parents have to kind of stick together in the same town. One parent can't just take the child and then moves to California. And it's the same thing with our immigration laws. If there is a mother and father and they're both in wherever, Colombia, we shouldn't say that one of those parents can take the child to the United States and break up that little child's home. So I think in the future when we do one of these bills, or if it gets to the floor of this session, we should say that we're not going to allow a child to lose one of their parents because one parent's going to the U.S., right? We should keep those parents together. So I'd like to thank the chairman for indulging me, and right, I never heard of those worst of the worst stuff. That's not the ship I'm on. So thank you very much.
Gentleman yields back. Gentlelady from Georgia is recognized.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Wisconsin.
Amendment to the amendment in the nature of a substitute to H.R. 9.
Without objection, the amendment will be considered as read. The gentlelady is recognized to explain the amendment.
Thank you, Mr. Chair. My amendment will add the mens rea requirement that to be criminally liable, a person must knowingly and willingly overstay their visit. As Ms. Ross pointed out earlier today, Title V would make overstaying a visa a crime, really for the very first time in American history. This is an egregious bill that has no exceptions or flexibility when it comes to overstaying a non-immigrant visa. Currently, there's no intent or knowing requirement provided in this new proposed crime, meaning that an individual can be punished even if they make an honest mistake about when they need to depart the country, or they're physically incapable of departing the country, or are unable to return because of circumstances beyond their control in their home country. That is why my amendment adds a common sense requirement that the person only be guilty of this crime if they knowingly and willingly overstay their visa. For example, a person who has a medical emergency in the United States cannot leave within 10 days of their visa expiring. You know, that would violate this new law, and they'd face up to 6 months in prison and a fine of up to $1,000, even if they're under medical care in a hospital or they're recuperating. So take into consideration that maybe a natural disaster prevents an individual from returning home for more than 10 days past the expiration of their status. They would be guilty of this crime and face 6 months in federal prison. My Republican colleagues have repeatedly called for mens rea reform, citing existing criminal statutes that fail to explicitly require a mens rea standard. But it appears Republicans' commitment to due process simply does not extend to immigrants, even those that are here legally. Last summer, we marked up H.R. 59, the Mens Rea Reform Act, which would insert a knowledge requirement in every existing criminal or regulatory statute that lacks an explicit mens rea standard. Republicans passed that bill out of this committee over Democrats' objections to an imprecise, one-size-fits-all approach that could lead to unnecessary, unintentional mistakes. My amendment would make sure that this new criminal statute embodies the drafting standard that my Republican colleagues claim to favor by explicitly requiring proof of knowledge and willfulness to obtain a conviction. Without my amendment, this bill would create yet another statute of the kind that Republicans claim to dislike. And it's not an adequate response to claim that prosecutorial discretion will address this issue. As Mr. Roy said earlier, we're Congress. We write the laws. And the idea that we would leave this level of ambiguity in the statute on purpose when trust in the Justice Department is at an all-time low, that's mind-boggling. It's ludicrous, and it's just plain old cruel. This Department of Justice tried and failed to indict a man for throwing a Subway sandwich at a DHS officer. It indicted an Olympian for touching the water of the reflecting pool after Trump's no-bid contract buddy miserably failed to make the iconic location American flag blue. And it indicted former FBI Director James Comey for posting a picture of seashells on Instagram. So let's not pretend that federal prosecutors under this administration are not bringing absurd and frivolous, unfounded cases. Without this amendment, this bill opens up a whole new avenue of cases federal prosecutors would be able to bring against people who had no intention whatsoever of breaking any laws. Our immigration system so badly needs reform. We have all said that over and over again. We're absolutely interested in bold new ideas to fix it, but this isn't one of them. If this amendment is not adopted, this bill would just imprison people for falling to circumstances beyond their control. This is not the kind of policy that I will support, and I vote yes on my amendment. I yield.
Gentlelady yields back. The gentleman from Wisconsin withdraws his point of order. The gentleman from Texas is recognized.
Thank the chairman. I oppose this amendment. You know, we debated this amendment in the last markup, in the last Congress. My friend from Texas, I believe, was the one who offered this particular provision in dealing with visa overstays, Mr. Moran. And, you know, he gave the example of probation, I think was the example that he gave, that we put people on probation and they're given terms or conditions to comply with the probation, and, you know, they do or they don't. And this happens all the time in state and federal courts. You know, you can't go to, if you're on probation, into certain places that serve alcohol, or there are other issues where you might violate it. And in many cases, maybe they didn't intend to be in a place, but yet they did. And so then it's a violation. And then that does yield back to the gentlelady referenced, which is something I referenced before, which is prosecutorial discretion in making determinations of whether somebody was, breaking the limit on their visa, with some sort of malice, or whether it was a good faith effort. But the point here is to put real teeth when someone is offered the ability to be a guest in the United States. And this is one of those things where I think we've culturally gone amiss, and certainly legally, where we've now got a situation where 40% of the people who are illegally here, at least historically, some of these numbers have shifted a bit in the last few years, but 40% are visa overstays. That's just unconscionably wrong. We've created a system where people are rewarded from ignoring the law. And again, it's just hard for me to believe that we have much sympathy here when it was the 19 hijackers were all visa overstays. And all we're trying to do here is draw a very clear line and say, look, you know when your visa is going to expire, and then you've got a 10-day grace period. But you gotta know when you're a guest, when you're no longer a guest, and to manage that. And again, I go back to prosecutorial discretion. If somebody's here on a tourist visa and working in good faith, and they had some period of time and they overstayed the visa and they missed the thing. They thought they had a certain period of time and got it wrong. I think the odds are pretty good that they wouldn't be pursued with force with respect to the criminal statute. But it's important to have that as a backstop to be able to let the world know that if you come here and abuse our goodwill to allow you to be a guest in our country and you overstay it, that there'll be consequences. That's the point. And I applauded my friend from Texas at the time for making that case, and certainly supported it, and certainly disagreed and voted against this same amendment then, and will urge that we oppose it now, because it is, I think, the right policy to set the policy cleanly and clearly, that there'll be consequences, and again, leave it to prosecutorial discretion to manage. I yield back.
Gentlelady from Vermont's recognized.
Thanks, Mr. Chair. I yield my time to the member from Georgia.
Thank you so much. I appreciate your yielding. Mr. Roy, I understand what you're saying, but there again, you're making blanket assumptions that everyone, these 40% or what have you, you're making blanket assumptions that everyone is deliberately trying to be here and overstay their welcome. It's just a blanket assumption that you're making, and that's simply not the case. I mean, there are people here for, as I said, for no reasons of their own. Life happens. As they say, stuff happens. And so to make the blanket assumption that everybody's deliberately trying to stay here and stay past the time of their visa, I think is absolutely cruel, and it's just unjust. It's not fair. And so there again, I understand what you're saying, but common sense, I mean, where's the common sense here? Where's the common sense in trying to be just and fair? And I agree with you. For people that are overstaying their welcome, their visas, and they knowingly are doing so and trying to buck the system, I get it. Yeah, I get that. But there are different circumstances that need to be considered for each and every one of these cases. And I have to be honest with you today, you can't honestly say that judges are making fair and just decisions about immigration. They're just not doing so. So I think there are mitigating circumstances that we need to consider. You need to take each and every one of these cases individually and stop just putting everybody in a one-size-fits-all category, because that's not life, and that's not truly what happens in the world.
Would the gentlelady yield?
Yes. Yes, I yield. Yield back to.
Yes, I yield to the member from California.
Just very briefly, we have a problem here in the tourism industry already because of the hostility that's been shown to people who come to this country. And if you're telling a tourist that, if you miss your plane or you get sick, you could be charged with a crime, there are other places to go visit. And I do think the economic damage from this is something that needs to be considered. I'm not for people flagrantly violating the law, but the way this is crafted is inelegant, and I think the gentlelady's amendment resolves some of that problems, and I thank the gentlelady for yielding, and yield back to Ms. Ballant.
Will the gentlelady yield?
I will. I'll yield to the ranking member.
First, let me start by thanking you, Ms. Ballant, but also I want to salute Ms. Lofgren on making that excellent point. You know, I had a group of business leaders from my district in my office not so long ago talking about the horrific effect that this violent immigration clampdown is having on people's desire to come visit the United States. People are literally afraid to come to the United States of America right now, and it is killing the hospitality industry. It is damaging hotels. My district is right on the border of Washington, D.C., and they're seeing dramatic reductions in the numbers of people who want to come to our country. Now we want to make it even worse and say, if you slip up, as the distinguished gentlelady from Georgia says, through no fault of your own, because there's a blizzard, or in this shocking climate change weather, there's hurricanes or whatever, and you don't get out in time, and now your visa expires, suddenly you're a criminal in the United States. When we're trying to get people to come here, to go to Anaheim, California to see the distinguished gentleman's district, or go to Disney World, or come to Washington, D.C., which used to be known as the center place of politics for freedom and justice all over the world. And now we're sending this really cruel, sick message. But the other point I really liked that the gentlelady from Georgia made was that this happens to lots of people, even happens to Republicans, to conservatives, where they're suddenly